Okay, so let's get right into it. We're talking about a huge Supreme Court case, Kennedy versus Braidwood Management, that honestly could have ended free preventive care as we know it. Things like cancer screenings, annual checkups, the stuff millions of us get without a copay. The whole thing boiled down to one central question. Was a key part of the Affordable Care Act actually unconstitutional? I know, that sounds like a crazy question, right? But this was the actual issue at the heart of this legal fight. A group of businesses sued, arguing that the whole system that makes this care free, well, they said it was built on a totally unconstitutional foundation. And their entire argument hinged on a small, really powerful, and, let's be honest, pretty obscure group of experts. And here they are, the U.S. Preventive Services Task Force, or USPSTF for short. Now, you've probably never heard of them, but these folks, a volunteer panel of medical experts, are the reason your insurance has to cover certain services for free. But the way they get their power, who appoints them, how they operate, that became the absolute focal point of this entire Supreme Court showdown. So how in the world did a volunteer panel of doctors end up in the middle of a massive Supreme Court case? Well, to really get the court's ruling, we have to rewind a bit and see how the task force's job changed over time, because that's what created this whole constitutional mess to begin with. You see, for decades, the task force was basically just an advisory group. They made recommendations, they published reports, but nobody had to follow them. Then, bam, 2010. The Affordable Care Act comes along and suddenly says that their top-rated recommendations, the A and B ones, are now legally binding. Insurers must cover them. And that huge shift in power is exactly what led to the lawsuit 10 years later. And right there, that's the legal tripwire. By making their recommendations mandatory, the ACA gave these volunteer doctors what the law calls significant authority. They weren't just giving advice anymore, they were effectively making policy. In the eyes of the Constitution, they became officers of the United States. And that title, well, it comes with some very, very specific rules about how you get your job. And this brings us right to the absolute core of the legal question. It all comes down to a really important distinction that the Constitution itself makes between two different types of government officials. The rulebook for all of this is called the Appointments Clause, and you can find it in Article 2 of the Constitution. Its main job is to make sure that anyone with real government power is accountable to our elected leaders, either the president or the heads of the big government departments. And to do that, it splits officers into two clear categories. So here's the difference, and it's absolutely crucial. Principal officers are the big shots. Think cabinet secretaries, ambassadors. They have to be nominated by the president and then confirmed by the Senate. No exceptions. But then you have inferior officers. They're still powerful for sure, but their work is directed and supervised by a principal officer. And because they have a boss watching over them, the Constitution says Congress can let them be appointed by, say, a department head, like the Secretary of Health and Human Services, without that whole Senate confirmation process. So this was it. This was the billion-dollar question for the Supreme Court. Are these task force members principal officers who were appointed the wrong way? Or are they inferior officers, which would make the whole setup totally constitutional? Everything, and I mean everything, about the preventative care mandate hung on this answer. All right, so after all the arguments, how did the court land? In a 6-3 decision, they handed down their answer. And in doing so, they gave some real clarity on the task force's status and, for now at least, secured the future of the mandate. And the verdict is in. The court said yes, the task force is constitutional. Why? Because its members are inferior officers. That means their appointment by the Secretary of Health and Human Services is totally fine. It's consistent with the Appointments Clause. So the preventive care mandate gets to live another day. The majority's logic really boiled down to two key powers the HHS Secretary has. First, the Secretary can fire any task force member at any time for any reason. The court said knowing you can be fired creates a here-and-now subservience. Basically, it keeps you in line. And second, the Secretary can actually review and even block their recommendations before they become binding. In other words, the buck ultimately stops with the Secretary, not the task force. And look, you don't have to take my word for it. This quote from Justice Kavanaugh's majority opinion really nails the whole argument. He says it all right here. Because the Secretary has the final say, that counts as enough supervision to make the task force members inferior officers under the Constitution. But hold on, it wasn't a unanimous decision. Not even close. 3 justices fired back with a really strong dissent, arguing that the majority was basically ignoring the Constitution's clear instructions and twisting the law to get the result it wanted.
Justice Thomas, who wrote for the dissent, put it pretty bluntly. He said the Constitution's default rule is simple. High-level officers need to be appointed by the president and confirmed by the Senate. He accused the majority of treating that rule like some inconvenient obstacle instead of the core constitutional principle that it is.
So where did they disagree so much? It really came down to interpreting just a few key words and old laws. The majority said that the power to convene the task force, especially when you read it with this government reorganization plan from 1966, basically gives the HHS secretary the power to appoint them. The dissent shot back saying, whoa, hold on. Convene just means assemble, like calling a meeting. You guys are stretching these old, vague laws to get around the Constitution's clear default rule. Okay, so we've been pretty deep in the legal weeds. Let's zoom back out. Now that this whole legal fight is over, what does this Supreme Court decision actually mean for you, for your healthcare, and for how our government is structured? Well, first and foremost, the big one, the mandate for no-cost preventive care is safe. This ruling says the way it's set up is constitutional. But this was about more than just healthcare. It powerfully reinforces the idea of executive accountability, confirming that a cabinet secretary's power to hire, fire, and review is what keeps these expert bodies in check. And finally, it provides a clear blueprint for how the government can use independent experts in the future while still playing by the Constitution's rules. And just as we wrap up, a quick but important reminder. This explainer is for entertainment and educational purposes only. This is not legal advice.